didn't understand a word which was not in English, not that well versed in language so far. Anyway, the issue is very simple. This hotel's possession, which was taken over recently, this was in news. This fight was continuing for some long time. A lease has expired in 2024. When it was taken over, the hotel was site was given. It was upon our SRM's insistence. A lease deed was executed, and it had certain terms. It was for a duration in '96. It was executed for a duration of 30 years, but backdated to '94. So, 30 years got completed in 2024. Now, somehow there were several issues. So many representations were given. Those representations were mostly not considered. The issue of renewal or outright sale also of a piece of land. In that scenario, all of a sudden, some 18 years old rents were demanded and were raised. Demands were raised retrospectively, enhancing the value of the land. So that suit was continuing. Asylum filed a suit for stay on disposition, then filed a suit for claiming of rent beyond limitation, and then another within period of limitation, how much is due. Now, when this was pending, this was going on, then all of a sudden, TTDC, the government agency, entered into the premises forcibly. So, group was forced to approach High Court, and learned single judge of High Court restoring the possession to the hotel, the group. They it highlighted an issue that nobody can be dispossessed by force in this manner. Ultimately, this issue traveled to Supreme Court, where court protected our possession subject to payment of certain demands. So we could not bring it to the notice of court at that time that the suits pertaining to rent are pending in trial court, and the issue, and we have already deposited 7 crores as demanded at that time under directions of High Court. So on next date of hearing, before court could consider, possession was again taken by TDC and the government. Now, in that scenario, court didn't hear us saying that you have not complied the order of depositing half of the total demanded rent. In this scenario, we could not bring it to the notice of court, though it was pleaded by respondent, the government TDC, before court in their counter that possession has been taken over on 22nd, 5 days before hearing of the date of the matter. So so this issue was not heard at all. Court did not proceed, said that you have not complied, and then it dismissed the petition. Now, the issue which is alive, which we want to bring to court's notice is that even a trespasser is entitled to some protection of law. We were leaseholders, our lease has expired. So for that also, there is a due procedure prescribed in law. Had we been a trespasser, we would have been given a notice under Public Premises Act for 30 days, represented against that notice or eviction notice. On its rejection, appeal would have gone to district judge. So a procedure is there. Now, we had considered this aspect that unless we bring it to the notice of court by way of a review petition, that the possession which has been taken over by force is actually against the Indian Constitution guarantees under Article 14, 19, and 22. Therefore, we have filed review. We hope court would consider it and pass some guidelines that no lesser, be it a government agency itself, they are not entitled to trample upon rights and just enter premises by force. That is why we are fighting. So if there is any question, I am ready to answer. Please let me. I'm sorry, can you please repeat it? Voice is breaking slightly.
He is asking the forcible acquisition has been already informed to the Supreme Court, or you are yet to inform to the Supreme Court?
No, it was not adjudicated before Supreme Court. The forcible possession, as respondent TDC and government filed a counter saying that we have taken over possession, but unless this is argued in court, it was not heard at all. And that is why we want to bring it to the notice of court by way of this review application. I'm very much hopeful for the only reason that the principle of law, as followed in all civilized societies of the world, and once the guarantee is given of due process and fair procedure, our job is to bring it to the notice of court, and we are hopeful that court would definitely consider it. At least this will become an example for entire country to follow. As lawyers, we are only concerned with facts and what as it happens. We don't know what if there is any political motive, so I may not be in a position to comment. I'm sorry. I'm sorry, sir. Again, some reverberation in the voice. Shiva, can you please explain me? I am unable to hear the sir.
Sir, he's asking, do you still have a hope that will you be able to get back the hotel position? He's asking.
Yes, for sure. Just like single judge, if you remember in the history of this matter itself, before High Court, when we went to High Court before single judge, judge restored the possession and directed them to get out. Now, if Supreme Court considers our plea, then Supreme Court can definitely put us back in possession. But we at least want this law to be enforced, that nobody should be allowed to take law in their hands, even if they are government agency. I think looking at our petition, we were confident that at least Supreme Court will allow some more time, but only TTDC can tell the reason for that fear and haste. I cannot tell what was in their mind. For certain, if they have acted by force and taken up possession, I'm not sure what went in their mind, but still, we had very sound case because this principle of law is being implemented since times immemorial. So this is what this conference is about. That group has already filed a review petition in Supreme Court itself to reconsider the order which they have passed, whereby the SLP was dismissed. Very good question. Sir, I have even received instructions to the effect that if the review petition is not considered, then we will move a curative petition before Supreme Court where three senior most judges, they sit along with the bench which decided the matter and they would consider that what is the point. Our review petition is based on this single ground only, that no one should be allowed to take possession by force. And if this is not considered by division bench of Supreme Court, we will go in for curative petition, which will be heard by 5 judges. So what I have gathered is that, see, TDDC, the land was granted to us. Definitely, we built building thereupon, and this hotel came up very well. It was in the posh area, working to the full capacity. Now, in the lease agreement itself, it was specified that in case this is not extended, then all removable items will be permitted to be taken away. We missed that chance. So as of today, we are not in possession of those. It's been blocked by PCC. Even if we are allowed to take it away, that would take another 4 to 6 months. So in any case, this forcible possession could have never been taken had even the lease terms been implemented in true spirit. I'm sorry, I was muted by myself. So first party was TTDC, second party was government, and third party was district collector. I've even shared my review petition copy. If anyone wants to have a look at it, they may have a look at it as well. There may be so many questions answered in them. Sir, in review petition, it has been filed. Now it will be processed, and then under Supreme Court rules, it is not brought in open court. It will be considered by the judges sitting in their chambers. Lawyers are not permitted there. The moment court finds that yes, this is an issue which must be addressed, then they put up for hearing in open court by giving notice to all the parties. So far, review petition has been filed and it has not been brought before either of the judges of the bench. So it would take some time, but we are following it up. Hopefully, it will be heard soon. Next bench in this matter will be the same bench which will consider the review. Review always goes before the same judges which have passed the order. It's only thereafter this matter when it is filed for curative, then it goes to five judges. Two same judges, the same bench, and three senior most judges. The trial on the rent suits, there are two suits pertaining to rent amount outstanding as claimed by them. One suit is where we have read that the demand of the rent raised retrospectively beyond 3 years is illegal and is barred by limitation law. Therefore, that demand cannot be raised. Second suit pertaining to rent is the last 3 years, the limitation period for the claiming of the rent, that amount of rent should be as per evidence. So both trial will continue. That is, there is no effect on those trials. As far as suit for possession, which was filed by suit for injunction from forcible dispossession, which was referred to mediation, where government is ex parte and TDDC is participating, is also pending before trial court. Now, that suit may have become infructuous, but we have rights under law to take back that possession taken illegally. So trial will continue. Yes.
He's asking if a review petition is allowed by the Supreme Court. Will they maintain
Yes.
the status quo or will it revert back?
For the consideration of the matter, they may direct status quo, but when it is decided that yes, they have taken over possession illegally, that can be reverted also. Is the question?
Sir, let me share the copies to them. Please give me.
Yeah. So if there is anything, they can send an email also. We'll revert.
Let me just share the copies to them in 1 minute, sir. If they have any question, let
Yeah.
us answer.
This review petition is only on the ground of forcible dispossession. Employees were there and then they had deployed their own team and they had not let some of the employees moved out. So our resident manager was, I think, not allowed to leave, but more facts can be disclosed by the person of the management present. I think you can show the photograph.
Yes, sir.
Where
we have shared.
There had been the kind of the manner in which the possession was taken. See,
which has been released.
Yeah. The foremost in the first example of this case itself, when it went to the single judge, it went with the plea of that they have taken over possession by force, and single judge gave an order directing them to restore the possession. So it's court's duty to put the clock back. Our job is to bring it to their notice that this has happened in this fashion. Yes, there is a plethora of judgments where this aspect, this principle of law has been reiterated that no one should be allowed to take possession by force. We will be citing all of those. Article 40 guarantees equal protection of law. Article 19 for protection of right to carry on business, and Article 21 is right to life, but it is also a article wherein due process and fairness in the procedure has been enshrined. So the way the possession is being taken over, it has violated all of these articles. Person who was staying and they file a complaint against us in consumer forum, definitely TTDC will be implemented. It is their action. We have not caused them any harm, but it is TDDC's action which has caused the harm.
Before some other court.
They can also join in if they want. They can also file an application before Supreme Court in our petition that this is the effect. That can also be considered by court. Any other thing which comes to their mind after reading review, they can send it to Siva by email. We'll answer.
Okay, sir. Thank you so much. Sir, thank you so much for your time.
My pleasure. Unfortunately, I couldn't meet all of them and see them, but at least they saw me.